Um, okay. Hi, everyone. It's great to be here. I'm Jenny Goldstein, Assistant Professor in the Department of Global Development. So I'm the faculty advisor for this new seminar in critical development studies, which is, for those of you outside of Cornell, might know that we have a PhD field that is aligned with the Global Development Department, but it's a little bit separate. It's formerly called Development Sociology. It's been renamed to be called Development Studies. So this is the sort of new seminar series we're running, sponsored by both the Development Studies field and by the Department of Global Development. So I'm really pleased to be relaunching the series with Shaina Potts as our inaugural speaker. We've got two really fantastic graduate student coordinators this year, Marvi Ahmad and David Balgley, who will be introducing Shaina and fielding questions as well. So I just want to say thank you for coming. We're doing this series virtually this year, so I hope you can also join for our next seminars as well. We have one on November 19th with Christy Thornton and one on December 3rd with our alum of our PhD program, Kasia Paprocki. So without further ado, I'll turn it over to David to introduce Shaina. Shaina, thank you again for joining us.
Thank you, Jenny. It's my pleasure to introduce Dr. Shaina Potts, who's an assistant professor in the departments of geography and global studies at the University of California, Los Angeles. Her work focuses on the intersections of law, capitalism, and geopolitics, with a particular focus on American empire, post-colonial sovereign debt relations, and territoriality. Shaina, the floor is yours.
Great, thank you so much. Thanks so much for having me. I just learned that I'm the first speaker in this series, which is a little daunting, but I'm excited to be here talking to all of you. So what I was going to do today is talk about the book that I've been working on and that I'm actually in the process of trying to finish a draft of to submit within the next couple of months. So I'm excited to share this with you and really looking forward to any feedback you have. And I'll start by talking a bit about the overarching argument of the book. And then in the second half of the talk, I'll sort of focus in on one of the chapters, which is on sovereign debt specifically. But the main argument of the book overall is that the transnational extension of domestic US law since around World War II has been an important but largely overlooked pillar of post-war American empire, as well as of the liberal international order that's so closely connected to that. So it's well known, at least among legal scholars, that law and jurisdiction have gotten increasingly complex since the mid-20th century. And people frequently say now that law no longer lines up as neatly as it once did with national and subnational state borders. Within legal studies, this is usually interpreted as a kind of natural and apolitical response to increasing economic integration. So my argument, in contrast to that, is that law and the flexibilization of law in this way didn't simply follow globalization, but rather has been a really important part of producing the form of economic globalization that we have today. And furthermore, that it's been driven, that this flexibilization of law has been driven by the interests of private capital, but also by the geopolitical and the geoeconomic interests of the United States in particular. So more specifically, the book project traces the expansion of US judicial authority over the economic decisions of foreign sovereign governments, and particularly over the decisions of foreign sovereign governments in the global South. And I try to show how this has promoted US-style private property rights and pro-business investment rules around the world, while simultaneously rewriting the rules of territorial sovereignty in important ways and undermining the economic sovereignty of other countries. I think this extension of US power through domestic law, to my mind, isn't really well captured in the idea of a shift from formal to informal empire, the kind of language that's often used in talking about sort of post-war American economic power, or in emphases on US economic dominance alone, or on studies of US influence on international rules and institutions. I really see this instead as a literal juridical extension of US power over other countries, precisely in the era of supposed formal sovereign equality. So what I wanted to do today was first just introduce a couple of key terms about law, and then I'll talk more broadly about how I see law functioning as a modality of US empire over time. And I'll very briefly talk a bit about the period from World War II to 1976 and the way that this extension of US law operates during that period, before moving in the second half of the talk to focus on the 1980s sovereign debt crises and the role of US courts and domestic law in bringing debtor states into line in that period. And then I'll try to draw out some of the implications of this for thinking about neoliberalization more broadly, as well as for bolstering New York and US financial power, and I'll say a little bit about how this works in sovereign debt relations today, including during the pandemic. So many of us, I think, tend to think about law as in terms of multiple scales as operating at either the subnational, the national, or the international scale. This is essentially a kind of hierarchical or a nested model of law. And I think if you ask many people what sorts of laws govern transnational economic processes, they tend to say international law, thinking of things like the WTO or at least trade agreements like NAFTA or things like this. And those are certainly a really important part of international economic governance. But this framework misses the significance of what's known as transnational law. And here we're talking not about international law made by supranational institutions, but rather about the extension of subnational and national laws of one country or state, in the US case, beyond national borders. And this is really what governs most cross-border economic transactions today, actually, more than properly international rules. US law, and in particular New York law, as well as English law, are by far the most significant legal systems in this process. So my focus is on that sort of transnational law. This sort of law really only becomes significant from the 1950s on, alongside the collapse of the formal European and US empires and shifts in the modality of transnational geopolitical power. So before World War II, US domestic law and judicial power were largely confined within US borders. Crucially here, this meant both national borders, sort of the mainland United States, and the colonial borders of the United States when the US started forming formal overseas colonies. So in the first half of the 20th century and most of the 19th century, US courts had a really important role in governing the relationship, for example, between white settlers and indigenous people, as well as between the mainland United States and territories like Puerto Rico. So they were involved, for instance, in deciding whether or not and to what extent the Constitution applied to subjects in the territories, and in justifying the sort of differential treatment of racialized populations, both on the mainland and in the colonies. Now, of course, the early 20th century was also a period of extensive US intervention in the economic and political affairs of other countries throughout the Americas in particular, and often in very, very direct ways, both in terms of military interventions, but also in terms of direct interventions in the economic ministries of some of these countries, in sort of what rules their central banks could follow or things like that. But crucially for sort of my analysis, this was almost always carried out by the executive branch during that time. The Department of State in particular was a really critical actor here. But US courts saw themselves as being sort of constrained from exercising authority over acts that they understood as to be occurring outside US borders. So this changes after World War II, when there's an increasing extension of US domestic law beyond US borders, in the way that we now sort of refer to in terms of transnational law. And this included the extension of law over the foreign government acts of other countries, including acts that occurred sort of in and beyond US borders. To my mind, this produced not just a new geography of US power, but also distinctive modalities of imperial power. And let's say a few things that I think are key about this. So first, this signifies a shift in the kind of power the US operates abroad from, especially over transnational economic affairs, from the executive branch to the judiciary in important ways. One effect of this is that it regularizes what were previously kind of ad hoc foreign policy responses to different sorts of transnational challenges. So instead of the executive branch sort of weighing in and deciding on, in a particular case, whether or not it wanted to intervene and what the kind of diplomatic or political costs of that or benefits would be, recasting these things in legal terms tended to mean that the US would also act in a more systematic way in these cases and intervene actually more regularly. This spread US style pro-capital and pro-contract property and investment rules during that post-war period, and really constrained the economic sovereignty of post-colonial states, just as many of these states were trying to argue for alternative economic practices, as well as both domestically and in terms of the attempt to create a kind of new international economic order that was based in large part on the idea that you could not separate political and economic sovereignty. At the same time, doing this through the rule of law, and the courts in particular, helped legitimate and disguise these new modalities of US power through the rhetoric of the rule of law. So as I said, US law really starts taking on this transnational role from the 1950s on. And my focus here and in the book is on the extension of this law over relations between private investors, usually US investors on the one hand, and foreign sovereign governments on the other, although I should say that this also applies and actually in a much larger volume to cross-border contracts between private parties. But when it came to trying to bring the acts of foreign governments within the umbrella of US domestic law, this involved rewriting the two key US legal doctrines that had previously prevented US courts from extending law over foreign governments in this way. So the first was foreign sovereign immunity, which is familiar to most people in some form, but basically foreign sovereign immunity rules determine whether foreign governments or their officials or their property can be sued or seized in US courts. And then another less well-known US legal doctrine is called the Act of State Doctrine. And this, in contrast, determines whether the acts of foreign governments carried out in that government's own territory can be invalidated by US courts. Here, a really prime example, which I'll mention again in a few minutes, has to do with like nationalizations of private property by post-colonial states in their own territories, whether or not US courts could question the validity of those nationalizations. So the classic version of each of these doctrines in the 19th and the first half of the 20th centuries pretty strictly limited the cases in which US courts could exercise authority over foreign governments. This is one of the most famous quotes on the Act of State Doctrine from an 1897 case against a Venezuelan military commander, where the Supreme Court of the US said that every sovereign state is bound to respect the independence of every other sovereign state, and the courts of one country will not sit in judgment on the acts of the government of another done within its own territory. And again, I want to emphasize here that, of course, the United States as a whole was intervening all over the place in sovereign states around the world, but that it was doing this not through this kind of judicial power, but through the sort of more direct interventions of the executive branch in various ways. So changing the rules, the US rules governing the relationship between US courts and foreign governments then really depended on rewriting these two legal doctrines. And there were two general legal strategies for doing this. One was that from the 1950s on, more and more foreign government economic acts get redefined from being considered public and sovereign, and therefore basically immune from US jurisdiction, to being cast as private and merely commercial activities. And therefore sort of as suited for judicial rather than executive oversight. And this literally depoliticizes very fraught geopolitical conflicts, especially with post-colonial states at the time, by recoding them as sort of merely mundane economic matters. And then the second is that there are a number of changes that loosen the spatial requirements necessary for establishing US jurisdiction over these kinds of government acts. So the first couple chapters of my book focus on the period from World War II to the mid-1970s, where you see the first major expansion of transnational US law in this way. And during this period, it was used really broadly in a number of different cases, primarily against African, Asian, and Latin American states to undermine or at least weaken the effectiveness of interventionist and developmental practices of various sorts. So a couple of examples here. One was in how state-owned enterprises and running state-owned enterprises were treated in US law. So in the early 20th century, US courts had held that, usually in cases involving European governments, that running state-owned enterprises was a sovereign public activity and that it was therefore immune from US jurisdiction, so that US courts couldn't challenge something that happened as a result of running a state-owned enterprise in another country. From the 1950s on, that gets reclassified as a sort of merely commercial private activity. Courts say basically that running a state-owned enterprise is just like running any business and that it shouldn't be treated any differently. Another example at the time is distributing or receiving food aid for malnourished populations. Again, in the early 20th century, in the context of World War I, participating in the distribution of food aid to needy populations was seen as a sort of sovereign public act that also gets reclassified in the 1960s and 1970s, largely in the context of US food aid programs to the developing world as a merely private commercial activity for which governments could be sued if there was a sort of contract breach or something. And then expropriations of foreign private property, which I mentioned earlier, was one of the sort of most significant sources of litigation during this period. So these sorts of expropriations were really widespread as an anti-colonial tool in the 1960s and the 1970s, where governments saw this as a really important for not only redistributing resources within societies, but specifically for regaining control over natural resources that were owned by by multinational companies, many of which had been set up in the colonial period. For the United States, it was the Cuban nationalizations of US property after the Cuban Revolution that were especially important here. The problem here for the courts was that nationalizations were, and actually still are today, considered quintessentially public sovereign acts, and thus beyond direct challenge by courts from other countries. So what happened in the 1960s and 1970s is that they weren't quite able to change the status of nationalizations themselves, but rather they used changes in both foreign sovereign immunity and active state law to reclassify various acts that were related to nationalizations as illegal, and to make this strategy basically useless for post-colonial states unless that state paid full compensation by US standards. So in all these cases, the post-colonial governments being sued here tried to claim what were essentially the same legal protections for sovereign acts that had been broadly recognized in the United States and other Western courts since at least the early 19th century. But as they did so, the rules of territorial sovereignty shifted through this litigation itself to allow US courts to apply US domestic law to more and more of these activities. By the mid to late 1970s, we see the collapse of many of these third worldist projects and the start of the neoliberal counter-revolution. And so that really changes the target of this kind of transnational legal expansion as well. And from the 1980s on, these sorts of developmental practices are less significant, although they don't drop out altogether. And sovereign debt becomes a really critical target for the further extension of US law. And that's what I'll focus on in the second half of the talk here. And that's what I focus on in the last couple chapters of the book as well. So just to say a couple of things about the 1980s debt crises for anyone who's not familiar. So the 1970s saw the breakdown of the sort of post-war era of Keynesianism and social democracies in the global north, as well as of various socialist and developmental projects in much of the global south. There were widespread structural economic problems in the global economy, stagflation most famously, so a combination of economic recession and really high inflation rates in many parts of the world. And this was associated also with a huge spike in lending to global South governments, both by official aid institutions like the World Bank and also by New York and London bankers. These latter commercial loans from bankers in New York and London were made in US dollars with variable interest rates. So what happened in the late 1970s and early 1980s is that when the US Federal Reserve Chair, Paul Volcker, increased the federal funds rate in the US from about 11 to 20% within a couple of years, this in turn then, because these were variable interest rate loans, increased the interest on all of those loans and sparked a massive debt crisis across Latin America, Africa, and parts of South Asia in the 1980s. So the debt crises and the US and IMF-led responses to them have led to what is now called a lost decade of development in many of these debtor countries, with negative economic growth, cuts in government social services, rising poverty and unemployment, and so on. And there is, of course, a huge amount of academic work on the debt crises, and in particular on the way the IMF and the World Bank exacerbated these crises through the imposition of structural adjustment programs. So these programs required debtor governments to liberalize trade and financial flows, to privatize state-owned enterprises, and to cut government spending on key social services. And in doing so, they initiated the neoliberalization of large parts of the global South. And they sort of worked closely in line with the US Treasury in doing so. So there's been a lot of attention to all of that, it's well rehearsed, but there's been much less attention to the role of US domestic law and courts in disciplining debtor states during this process and in further encouraging neoliberalization during this period. So that's what I'll focus on now. So basically, before the 1980s, sovereign debt was considered a strictly public and political activity that, again, like state-owned enterprises before it and expropriations, could not be directly challenged or questioned by US courts. There was some pushback against this in the 1970s already, but there was no change in the formal status of sovereign debt in US law until the 1980s crises. During the debt crises, private litigants sued sovereign debtors in US courts, and US judges responded in ways that allowed them to bring those debtors within the authority of US courts in certain ways. In particular, this was done to allow what's known as holdout creditor litigation against sovereign debtors. So holdout creditors are basically private creditors who refuse to participate in the kinds of widespread debt restructurings that were being negotiated by the IMF, the US Treasury, and debtor states in the 1980s. Most private creditors were participating in those restructurings, but a handful said, we don't want to take these reduced terms. We don't want to accept any kind of a haircut on the contracts we're holding. Instead, we're going to sue these countries, mostly in New York courts. So there's a lot to say about how the US law changed in order to bring third world debt within reach in this way. And I'm just going to flag here 4 of the key legal mechanisms that were used to do this in the 1980s and 1990s. So first, there were 2 important changes in the way that the geography of debt was defined in US law. So one was that courts changed how they understood the location or the situs of a debt. So in the 1960s and 1970s, these same courts had defined the location of a debt as being with the debtor. At the time, this was used in cases against Cuba and Iraq, for instance, who had nationalized businesses in their home states and tried to nationalize the accounts of those businesses. They claimed to be nationalizing the accounts of those businesses as well. And in that context, the United States courts argued that money owed to those accounts was located with the debtors in the United States and therefore not included in the nationalizations. So it was out of reach of the nationalizations. In the context of the 1980s debt crises, the same courts shift gear and redefine the location of the debt as being with the creditor, which now in this context means not in the debtor country. So this was especially important in the first case that did this was a case in 1985 against Costa Rica, where the court said, well, actually the debt is located with the creditors who were New York bankers. Therefore, the debt is located in the United States, and therefore it's within US jurisdiction. In another case, a few years later against Argentina, the Supreme Court also further weakened the rules for determining whether an act had direct effects on the United States for the purposes of establishing jurisdiction. And here the court said that while in previous cases, in order for an act to be direct, it had to be foreseeable and substantial. The court redefined this to say it merely had to be an immediate consequence of that act. This was used in this particular case to hold that even debts held by non-US creditors, so example by French banks, say, but on which some payments had been made in a New York bank account, counted as being in the United States for the purposes of claiming US jurisdiction over them. So of course, with the growing importance of New York finance and Wall Street, and the prominence of New York banks in pretty much any major global financial interaction, this gives courts the ability to say that pretty much any debt relation that has any minor connection with New York can be considered as being located within the US. A second set of legal strategies at the time had to do instead with reclassifying the kind of activity debt was. The changing the status of debt from being considered a sovereign debt, from being considered a public and political activity, and therefore immune from US jurisdiction, to being in the same case against Argentina, I just mentioned, the court reclassifies that kind of issuance of sovereign debt as a merely private commercial activity and therefore not immune from US jurisdiction. So the court says that basically corporations also issue debt, therefore issuing debt is a garden variety commercial activity and doesn't need to be treated any differently just because it's a sovereign doing this. This strategy in turn depended on the court really narrowly defining the scope of the act in question. So Argentina had, in this case, issued the particular bonds in question as part of a much broader program in the 1980s of trying to stabilize its exchange rate and its sort of a fiscal situation in the context of these massive debt crises. And throughout the litigation, Argentina itself argued that the context had to be understood much more broadly and that the debt was just one component of a much broader set of sort of crisis measures, which only a sovereign government, they said, would or could carry out. But the courts rejected that view, defining the act in question here as the mere issuance of debt alone, and insisted that it was isolated from these broader efforts to counteract the crisis. So those are just the most important legal changes in the 1980s that really extend the power of US law over sovereign debtors at this time. Together, these changes then sort of expanded US judicial authority over all transnational sovereign debt relations and directly enabled private creditors to sue sovereign debtors in a way that they wouldn't have been able to before the 1980s. It also had the effect of ensuring that contract enforcement would outweigh all other policy considerations here. This transnational extension of US legal power also worked in tandem with ongoing structural adjustment programs in important ways. So the debtors that were sued in the 1980s and the 1990s were all participating already in IMF-led restructurings and structural adjustment programs. So this was no longer the 50s or 60s where the governments involved in this litigation were often consciously trying to kind of set up an alternative economic path, whatever the flaws of that developmental model, but rather one in which the governments were already capitulating pretty directly to the United States and the IMF in implementing neoliberal structural adjustment programs. And at the time, and now actually, holdout litigation like this was often seen as being in tension with those IMF-led restructurings. So many argued that such litigation was interfering with those structural adjustment policies and the debt negotiations, because these were precisely creditors who refused to participate in those deals and said, no, I want to get a full payment on my debt contracts instead. In fact, however, the two strategies, sort of creditor litigation and debt restructuring, were much more closely intertwined than that and reinforced each other in significant ways. So the possibility or threat of holdout litigation actually gives all creditors more leverage in debt restructurings, to the extent that debtors are afraid that more creditors will take this litigation route, and has been shown to impose basically harsher discipline on debtor states than without it. At the same time, the fact that debt restructurings were occurring and that most creditors were participating in those restructurings was the only thing that made it possible for debtors to pay these holdout creditors when they lost these lawsuits at all. This relationship was actually recognized at the time by courts and by New York financiers, as well as by the US executive branch in a number of cases in the 1980s and the 1990s. And it was made especially clear, this relationship was made clear in a quote that I find really useful from a 1997 decision against Peru, in which the court summed up what it understood to be US policy on this issue. So after praising Peru's compliance with an IMF-mandated reduction in the government deficit, with the consequent firing of thousands of public sector employees and the privatization of many of the state-owned enterprises, the court went on to nevertheless allow a handful of holdout creditors that had refused to participate in that IMF deal to collect on their contracts. And in doing so, they said, first, the United States encourages participation in and advocates the success of IMF foreign debt resolution procedures. Second, the United States has a strong interest in ensuring the enforceability of valid debts. This second interest limits the first, so that although the United States advocates negotiations to effect debt reduction, it maintains that creditor participation in such negotiations should be on a strictly voluntary basis. So basically, the US government and the court said, yes, we're all for IMF and structural adjustment programs and so on, but upholding contract rights and the ability of creditors to enforce those in court is actually a more important policy priority. So what are some of the general implications of this extension of US judicial reach over transnational debt relations in the context of the 1980s? One was that this really helped bolster then neoliberalization more broadly, precisely by working in tandem with structural adjustment programs to discipline debtor states and impose even harsher discipline on debtor states, as well as by really narrowly defining more and more state economic activities as merely private and contractual. It also, I would argue, bolstered the power of Wall Street and the US dollar more generally, and specifically of the sort of financial system on which US empire was increasingly dependent since the 1970s. And here, New York legal and financial power were really interdependent in important ways. So these kinds of legal changes bolstered the power of private creditors over debtors. And at the same time, the growing power of Wall Street was ensured that very few countries could afford to disobey these US court orders. So on the one hand, and people often say, well, why does a foreign country obey these US court orders? There's no sort of police mechanism for directly enforcing these sorts of decisions, which is true. But for the most part, the economic costs of disobeying these kind of court orders have been enough to ensure that countries have obeyed them most of the time. These changes in the 1980s and 1990s also established what is still the current legal architecture for governing sovereign debt today. So this is a kind of a simplified sketch of that architecture, but basically there are sort of three key components of what is often now referred to as the informal sovereign debt restructuring regime. So basically those are the original contracts between the debtor countries and private creditors. And then you have the transnational extension of New York or English common law to govern those contracts. And then during crises, you have these IMF and US Treasury-led ad hoc debt restructurings. These are sort of always carried out on a case-by-case basis. There's been a lot of resistance to saying that we should develop sort of more systematic rules for debt restructurings. What's really critical about these restructurings is that while they are essentially mandatory for debtors, so not only will you not get a restructuring if you don't participate, but you'll have no access to IMF bailout loans, for instance, if you don't participate in these kinds of restructurings as a debtor. They are always and by design considered voluntary for creditors. And what gives this insistence on voluntary participation teeth is precisely the fact that these creditors can participate in holdout litigation instead and sue those debtors in US or secondarily English courts. That sort of closes the gap here, closes the loop here, and brings sovereign debt governance back to the terms of that original contract and their enforcement. So just like in the 1980s, this system still continues to give private creditors in general greater leverage during debt restructurings, even when they do participate in those negotiations than they would have otherwise. The commitment to this framework since the 1990s has stymied all real efforts to reform the sovereign debt system since then. This includes most famously interfering with an effort by the IMF itself to establish a more binding sovereign debt restructuring mechanism in the early 2000s, as well as a 2014 effort by the UN General Assembly to establish a similar framework, but one that would be housed at the United Nations rather than the IMF. In both cases, those efforts were defeated by opposition from the private sector as well as by powerful creditor countries. And the arguments used against them were made on the grounds that such a binding mechanism would interfere with supposedly self-regulating sovereign debt markets, and that it would do so in large part by making creditor participation in restructurings mandatory rather than voluntary. Most recently, these same arguments have undermined the only real international effort to provide any debt relief to low-income countries in the context of the COVID-19 pandemic. So under what's called the Debt Service Suspension Initiative, the G20 creditor governments have provided about $5.7 billion of debt relief on debt payments from low-income countries. It's not much in the scheme of things, but it's something, I guess, and is the only real direct debt relief effort there has been so far. But there's been no attempt at all to require commercial creditors to participate in these efforts. And the creditor countries involved have all said publicly, we encourage our own private financiers to participate in this program. And not surprisingly, perhaps none of those financiers have volunteered to do so. So this commitment to voluntary participation only and the ability to sue sovereign debtors that this depends on have hampered all major debt relief efforts during the pandemic, even in a context now, unlike in the 1980s, where the IMF, the World Bank, and the United Nations are all at least outwardly recognizing the severity of the economic crisis and the way that debt burdens are directly contributing to this. So just some conclusions to wrap up here. While the legal structures underpinning today's sovereign debt regime were established in the 1980s, and they've served the interests of New York finance and private creditors since then, my argument has been that these are only part of a broader shift in the modality through which the United States and global capital have exercised power abroad since World War II. In the pre-war period, even as the US executive branch intervened throughout the Western Hemisphere, US domestic law and judicial authority were generally confined within the official borders of the United States, both on the mainland and in its formal overseas territories. This changed, though, as the European empires collapsed and as direct colonization lost legitimacy. As the US became a global superpower after World War II, in that context, it adopted new imperial modalities. And so alongside economic coercion, military expansion, and just sort of directly shaping the post-war international system, my suggestion here is that the US also continued to exert direct juridical power over other countries through the transnational extension of US domestic law and judicial authority in these ways. In the first decades after decolonization, this was used to defang developmental economic practices like state-owned enterprises or nationalizations of private property. But with the shift towards neoliberalism and financialization from the 1980s on, this same tool was refashioned to bolster the power of New York finance and the US dollar. So this form of legal power has had a lot of advantages for the United States. It's more regularized and rule-based and therefore also less obvious than other imperial modalities. It's helped spread neoliberal conceptions of the public and private and sort of forge globalization of a certain kind by doing so. While still, I would say, promoting the interests of both the United States and global capitalism above all other economic considerations. At the same time, the fact that this form of power is enshrined in US and especially New York law and not in direct action by the executive or legislative branches raises several important questions about the future of this sort of legal power today, especially as US dominance and legitimacy in the 21st century decline. So questions like, will other legal systems move in to take the place of transnational US law? Or will US law itself simply become less attached to US geopolitical interests and more connected to other rising global powers and so on? And I'm happy to talk more about that in the Q&A, although I think in general it might be too early to answer these questions definitively. But either way, I do think that this sort of transnational law, whether it's based in New York or somewhere else, will continue to play a really important role, I think, in shaping both global capitalism and geopolitical dynamics going forwards. And I will stop there. Thank you.
Thank you so much, Shaina, for a really fascinating talk. It's a lot to think about, to think with. I'd like to open things up for questions now. Feel free to either raise your hand in the reactions or to put the question directly in the chat. If anyone wants to ask a question anonymously for any reason, feel free to private message me through the chat, and I'll be happy to ask on your behalf. David Kay, please.
Yeah, well, I have two questions, which I hope you could answer somewhat briefly. Could you talk some about your research methods and sources and like how you learn, you know, a sort of at a data collection level about what's going on in this arena? And then the second question was, you talked about sort of, you know, the enforcement issues around courts, essentially because New York has so much financial power, but you did allude to some exceptions. I wonder if you know, where some sovereign states apparently ignored the courts. I wonder if you could talk a little more about those cases and what they signify or not.
Yeah, thanks. Yeah, on the methodological question, I mean, I got into this project sort of backwards, I guess, which was through an interest in sovereign debt and sovereign debt crises. Focusing on, in particular, on the Argentina crisis and a bunch of litigation against Argentina in the 2010s by hedge funds suing Argentina to collect on debts that Argentina defaulted on in the 2001 its 2001 crisis. So I sort of started there, and then I got increasingly interested in how it was that these courts had come to have so much power, and so much power that was to me, sort of seemed strange to everyone outside of law and business circles, but seemed completely normal to everyone who worked in those domains. That it seemed normal to them that a New York judge could sort of tell Argentina what to do in this situation. And so then I started with that case, and then it was became a sort of more archival case, I guess, largely through legal documents. So because this is common law system based on case precedent in particular, the courts themselves are citing constantly, and the litigants in these cases are citing previous cases and arguments, right, and both either trying to bolster their position or distinguish what's happening here from previous cases. So I did a lot of kind of tracing backwards the legal concepts and sort of strategies that were being used in the Argentina litigation and trying to trace those back. And that's what brought me eventually back to not only the 1980s, but then seeing how the law developed in the 1980s was itself built in large part on law that came out of litigation involving Cuba in the 1960s and 1970s, and then sort of going back from there. In addition, I've read a lot of the secondary legal scholarship, which traces, the history of these doctrines and so on and so forth. And just, I guess, a general point I'd say is that, I wasn't trying in this research to find unusual or sort of hidden cases, but rather to say, well, what are actually the cases that most legal scholars consider the most important cases here? And then I think to approach those cases and reading those cases in a different way than legal scholars have tended to. On the question of resistance, I guess, again, the primary example would be Argentina, which refused for several years to obey New York court orders, directing it to pay these hedge funds who were suing Argentina in the 2000s. Those were holdout creditors like the ones in the 1980s. One of the things that happened as a result of these legal changes in the 1980s and the 1990s is that whereas those holdout creditors had mostly been banks of various sorts who were already holding debt of these countries when the crisis happened, because it becomes possible to sue countries in this way, that really lends itself to encouraging the kind of vulture fund strategy or distressed debt strategy, where creditors now specialize in buying debt very cheaply after a crisis occurs in order, for some of those hedge funds, in order to pursue this kind of litigation. So those were the kinds of hedge funds that were suing Argentina. Argentina refused to pay, partly because that was possible, partly because of the political situation in Argentina in the 2000s under the Kirchner governments, who had a very vocal kind of anti-neoliberal and anti-US imperialism stance, whether or not they were fully anti-neoliberal in their own policies. And so they also were able to get a lot of domestic leverage out of saying that they were refusing to pay, showing that they were refusing to obey these court orders. But eventually in the 2000s, which I didn't talk about today, but the courts developed some new enforcement techniques that basically made it even harder for a country to refuse to obey, primarily by saying that that country then could basically not engage in making any of its other financial payments if it didn't pay these holdout creditors first. And Argentina tried to disobey that order, held out for another 2 years, and then there was, but it also meant that I had no access to other international financial access. And in the next election in Argentina, there was a kind of political turn, and the sort of center-right president paid off the vulture funds in full. So that's probably the best example of a state refusing to obey for a while, but yeah.
Yeah, Jenny.
Shaina, this is such a fantastic talk. Thank you so much. I never thought that US legal cases could be made so interesting, but you have done it, and I'm so excited for your book. So I guess my question is sort of thinking, and you hinted at this in your conclusions, but in thinking about how at some point the system will change, right? Whether it's this decade, next decade, we don't know. Where do you think the kind of clearest points of leverage for change are, right? Not assuming that it's a change for the positive necessarily, but just like moving forward, where are the weak points, I guess, in the system that you're describing, right? I don't want to ascribe too much agency to any one person here, but do you see weak points? Is it with the financial system itself, or is it sort of more on the US legal side?
Yeah, I mean, I think the most likely avenues for change are not especially hopeful ones, I guess. I mean, for one thing, I think most likely New York law will continue to be a really significant pillar of the system, even if it becomes more attached to serving the interests of China or other states in certain ways than of the US government. So in the period, I mean, I think that's been one of the tensions for me all along in this project, is really trying to figure out how to think about the relationship between kind of US geopolitical interests and sort of the way that this law serves global capitalism more generally. For most of the period that I'm talking about, the executive branch was really directly involved in supporting these changes, and sometimes was actually the one in trying to get the courts to agree to take more responsibility than the courts initially wanted to take for some of these actions. That really changes by the 2000s. Though, by that point, the courts, in the quote I read from the Peru case in the 1990s, the courts were sort of still at that point always trying to show that their decisions on cases involving foreign governments were in line with US foreign policy. There was a kind of, I think, defensiveness about that. And that really changes by the mid to late 2000s when these courts are much less likely to say that there's any need to consider foreign policy considerations at all in cases that involve commercial activities, even if foreign governments are involved. And that's been true, again, in the Argentina litigation, even when the executive branch says, hey, there actually are really serious foreign policy concerns here where we actually don't like where you're going with this case. And the courts have said, too bad. So I definitely think it's possible for New York law, I think it already has to some extent, to serve other geopolitical interests and just sort of more broadly private capital as things shift here. But there is also increasing competition for governing law from other centers. So England is also a really important, has been for a long time, a really important source of this kind of governing law as well for a lot of business contracts. But increasingly, to some extent Chinese law, but especially the law of certain places like Singapore and Malaysia and Hong Kong, I'm not sure what's happening with that right now, have been important too. I'm not an expert on any of those legal systems, but I think you'll start seeing also some competition there. But the question for me is whether those are going to change the content of these legal rules at all, or whether it will just be a sort of change in where that law is situated, and therefore, to some extent, sort of which cities and financial centers benefit the most from these kinds of practices. I mean, I think in terms of sort of more resistance to this legal power, probably the main possibility for doing that, I don't know if there's any likelihood of this, is for places to sort of set up regional financial alternatives where these financial practices wouldn't be so tied to moving through these most powerful financial centers. But that I think there's maybe a long shot, but yeah.
Yeah, Marvi, go ahead.
Hi. Okay, so this was a really interesting talk, and I have some questions which are also kind of related to the resistance to this. I actually wanted to specifically ask you about the role of public discourse and kind of like in debtor states, which may have the power to kind of push back on some of this, and if that is even taken into consideration by some of these creditors in the West. For instance, every time a new government comes to power in Pakistan, there's a very strong kind of public outcry of, are you going to pander to the West? Are you going to take more loans? Are we going to be servants of the West again? I mean, this is increasingly, this has become a very important part of public discourse, and when you're trying to get elected. And Imran Khan, the latest prime minister, made a very big point about, no, I'm never going to go back to the IMF, etc. Of course he did, but it becomes a very important sticky point in that sense. And it seems like in the last point that you were just talking about how more regional sort of like creditors to break the system, it seems like many people, for instance, in the global South and in Pakistan, in that case, are very interested in like, oh, we're okay with taking loans from Saudi Arabia or the UAE or something, but just not the US. And I wonder if that sort of like pushback from in this kind of like geopolitical public discourse space has any role to play in any kind of restructuring of this that we might see in the future.
Yeah, thank you. Yeah, that's a great point. And yeah, maybe even makes me revise some of what I just said in a certain way. I mean, for one thing, I think you're absolutely right that the primary locus of possible pushback is in resistance to these economic structures of these kinds of debt relations more broadly, rather than in people trying to resist these particular legal rules per se, if that makes sense. And but that said, there actually have been, so from movements like Jubilee UK and so on, there have been efforts to get governments like the British government or the US government to impose new legislation that would outlaw this kind of the most egregious of this kind of vulture fund litigation, for instance. So that would be a way in which at least sort of aspects of this legal structure. If there was sort of legislation either here or potentially in other countries, especially if that went hand in hand with sort of a shifting regional focus. Again, I mean, I don't know anything about Saudi Arabian creditor practices and whether they have different rules for enforcing those or not, but I think that's really interesting. But I do think the sort of biggest source of resistance to this comes from those kinds of movements, for sure. One thing that I think is especially pernicious about this kind of legal power is that precisely because it is these sort of legal arenas are seen as very technical, esoteric legal domains, they don't tend to be widely talked about and to get a lot of attention, a lot of direct attention, I think, even in sort of more broadly anti-neoliberal political practices. Yeah. Thank you.
Yeah, Aman.
Hi, yeah, thank you so much. That was such a fascinating talk. I really, really enjoyed it. I had just a couple of questions, one of which you sort of, I think, partly covered, which was just around if you could talk a little bit about, in a systemic sense, I mean, I think like Elliott Management in Argentina, the case is well known, but in a systemic sense, what you see in terms of the types of financiers and creditors that are sort of more regularly seen as holdout creditors versus those that do participate in regular debt restructurings. So that was sort of one big question. And then the second was just about how do holdout creditors actually make their case? Because distressed debt seems so, I mean, it seems so obvious that distressed debt comes with a certain risk in terms of making that investment. So in legal proceedings, but also in sort of, let's say, the court of public opinion, how do holdout creditors go about making their case that they are sort of should be privileged to these kinds of terms? Thank you.
Yeah. Thank you. On the first question, did you mean, can I just say a little bit more about which actors are involved in the holdout versus other? Okay. Yeah, so since the 1990s, there's just, as I think I was just saying briefly before, there's been really an explosion of specialized distressed debt investing. And these have increasingly been specialized investment firms, so hedge funds largely, but various other kinds of mutual funds and things who specialize in distressed assets. Now, some of those creditors do that. They buy these distressed debt assets after a crisis at very low rates, very low prices, in order to restructure the debt. So they plan to basically participate in restructurings, and they still make a huge profit because they bought the debt at such a low price. In those restructurings. Others pursue this holdout litigation strategy. But institutionally, I'd say they tend to overlap a lot. Actually, there's not a really clear distinction between the ones who participate in litigation or not. And actually, often the same hedge fund will participate in a restructuring in one case, but pursue this kind of holdout strategy in other cases. One thing that you see more broadly in that kind of, especially in the distressed debt realm, is a fusion of lawyers and financiers. So a lot of the financiers in these hedge funds have legal backgrounds now, and are really using those legal backgrounds to identify what they'll say, sort of identify opportunities, in the debt contracts, and they'll really read these contracts in a great amount of detail in order to see if there's a kind of legal opportunity there to pursue. Yeah, in terms of the legitimacy of this in the court of public opinion, I'd say the vulture funds who pursue this litigation are probably are sort of maybe some of the most widely reviled in sort of the popular press, financiers in the popular press. To me, one thing that's interesting is that while I think that's totally merited, the distressed debt investors who do participate in restructurings then are often held up as sort of somehow the good distressed debt investors, in contrast to these more predatory financiers. But again, I think that's sort of drawing too much of a line actually between those two strategies. In terms of whether I think those financiers themselves are simply not concerned about what the general public thinks about them. And not just because they're financiers, but I think also these distressed debt investors in particular really have embraced a kind of very masculinist narrative about being the most daring maverick financiers And so if you look at some of the distressed debt websites or in these distressed debt conferences, there's a lot of this talk about how they're the ones who are willing to engage in these supposedly really risky practices and so on. Whether or not it's really that risky when you have this kind of legal support, I think is an open question. And for the most part, they make quite a lot of money on these, even if they don't win every single every single case, but that narrative of being these kind of maverick financiers is really strong in this subfield of finance. But yeah, there was a huge amount of outcry about the Argentina litigation in particular, which was very well known compared to most cases like this. I think among the more sympathetic people, what you see then is not so much that they say approving things about the vulture funds, as that they say, well, whatever the situation there, once the Supreme Court, once the US courts made this ruling, it's just so important to follow the rule of law. It's just the rule of law is so powerful, and that rhetoric is so powerful that I think that's what kind of plays the other side of that. Thanks, good question.
Fuad, do you want to ask your question?
Yeah. Thank you. Sorry, Shaina, I'm losing my voice a little bit, but thank you so much for that wonderful and very illuminating presentation. I'm curious if there are instances where US law contradicts international law regarding debt, nationalizations, and so on. And what happens in those cases? Or is it really the case now that the two are so aligned with each other that you don't find many cases where they contradict each other? And the other thing is, you didn't say much about extraterritoriality, which was much more common during the colonial and in the early part of the post-colonial period. Has that gone? Is that now no longer a functional means for enforcing some of the things that you were talking about? And lastly, is there any other recourse for the debtor countries in any kind of judicial body at the international level? But thank you again, really wonderful work.
Thank you. Yeah, great questions. Maybe I'll take the one about extraterritoriality first, and then so yeah, in the colonial period, that term was largely used to refer to sort of these consular courts where, so like the British would say, our citizens in China, for instance, won't be subject to Chinese law. We're going to set up our own courts in that, or in the Ottoman Empire, we're going to set up our own courts in that system. And if anything happens involving our people there, they'll be tried in our own courts, and it's according to British law and not Chinese law. That probably has its closest corollary now, I'd say, in US military sort of status of armed forces agreements, where the US military does something very similar and says that US law applies to military bases abroad, but also often to US personnel, even if they commit crimes sort of off base in certain cases, and so on and so forth. So I think that is sort of the most direct descendant of that kind of extraterritoriality. But I should say that legal scholars do often use the term extraterritoriality now to describe the sort of the flexibilization of law in the post-World War II period. They usually use it to talk about explicitly extraterritorial statutes. So where a country, mostly the US again, although other countries are starting to do this more, where a country passes a statute that explicitly claims that kind of extraterritorial reach, to say the US has a right to prosecute, so antitrust cases, for instance, against foreign businesses or cartels, is one of the most famous ones. Those I think are really important. To me, the reason I didn't talk about this in terms of extraterritoriality is two reasons. One is that this kind of extension of US law, which is considered much more mundane than that, and this is considered sort of just simply the extension of US commercial law, basically, and it's not usually talked about in the same discourses as even legal scholars are talking about extraterritoriality in. So because extraterritoriality is still sort of seen as something more exceptional and sort of politically significant, whereas this gets sort of classified as a kind of the sort of simply the globalization of law or something like that. I also, and I didn't get into this today at all, I sort of think about this more as I think it's more helpful to me to see this more as an extension of US territoriality in certain ways, rather than extraterritoriality, which I think draws a kind of sharp distinction between what happens in the US and elsewhere. But yeah, it's absolutely true that there are some really significant connections between this and certain kinds of extraterritorial jurisdictional reach in the colonial period. On the question of US versus international law, yeah, it really depends on the particular question, but the short answer is that specifically on issues involving foreign sovereign immunity and on expropriations, the US has refused to sign certain international agreements because its own rules are harsher than, or harsher from the perspective of other countries, than the international rules that the UN has agreed on, that the General Assembly has agreed on. So there has been an attempt in the 2000s for a number of countries signed a UN Convention on Foreign Sovereign Immunity rules, but it would actually have restrained the power of the United States in certain ways, precisely because it refused to classify as many things as merely commercial. So it kept sort of certain things out of that domain, and it had stricter rules for the sort of stricter spatial requirements for finding direct physical connections or spatial connections between an activity abroad and the jurisdiction in question. So the US has rejected that convention on both of those grounds. At the same time, one thing that I found really interesting is that there is a kind of interplay between US law and international law. So on the one hand, of course, US, not surprisingly, the US and US courts have been really influential in shaping a lot of international law in the 20th century. That also works though in reverse, where US courts often invoke a supposed consensus in international law, but one that's not really enshrined in any particular treaty or anything, but they'll say, well, basically all states agree that expropriations without compensation are clearly against sort of the rules of civilized commerce or something like that. And they'll use that rhetorically to justify their own sort of domestic legal changes and the extension of US legal power in that way. Yeah, so that was to that. And then I'm sorry, Fuad, the last question, could you remind me?
If there were any other institutions at the international level that debtor nations can have recourse to?
I see. Not really in the sense that they can appeal. There's not, like, once you go to the US Supreme Court, there's not a kind of higher international court to appeal to. Debt has tended to still be heard in these kinds of domestic courts. Other cases, including cases involving expropriations, have tended to move more to international arbitration rather than sticking with these domestic courts. So there are a few different sites for that, ICSID, which is housed at the World Bank, but certain other sites for international arbitration. Those are probably more properly international in certain ways, but they tend to be a sort of different set of cases, and those have been themselves largely staffed by jurists trained in Anglo-American law schools, and have tended to apply those sorts of principles pretty strongly. So I think like the UN General Assembly attempt in 2014 to set up a multilateral debt restructuring framework was an attempt to create a kind of international institution that would supersede these domestic legal practices, but that was really, even though the vote for that at the General Assembly was something like 124 voting yes to 11 voting no, and then 40 abstentions, but it just went nowhere because every single creditor country voted against it.
Yeah, Jenny.
I didn't mean to steal someone else's question. If they've got any others, feel free, please, people raise your hands. So I guess I was thinking a little bit about China. You just mentioned it really briefly in passing. Given that from my limited knowledge of what China is doing sort of around territoriality, seems like, sort of the biggest threat to territory in a kind of traditional sense, right? Just in terms of building islands, right, in the South China Sea and things like that. You know, what they're doing with Taiwan and of course in Hong Kong. Are they like, what's their role here? Are they seen as a threat by financiers or by the US legal system, or are they trying to push for their own version, or are they sort of outside of this altogether?
Yeah, the short answer is that I really don't know enough about China, but I think those are fascinating questions. And I in particular don't know, but I think it would be so interesting to think more about how those kinds of sort of physical territorial processes, like the island building or the military threats against Taiwan and so on, how those relate to their own practice in these other ways. So my understanding is that there are more loan contracts in particular now being signed under Chinese law. But I don't have a great, and that for the most part, a lot of the contract terms are pretty similar. So that's not necessarily a big change in terms of the kind of rules there, but I don't know enough about sort of the enforcement of those, or sort of, you know, to know what that looks like if you go to a Chinese court to adjudicate that kind of loan. And then of course there's, you know, huge debates about whether Chinese loans, because they don't have the same kinds of conditionalities as these, you know, IMF loans and so on, are sort of better or not for debtor countries and so on and so forth. So yeah, I guess the question is, I don't know. I'm not sure whether US jurists are concerned about China directly, but I think they have been, you know, very open about making the argument that to the extent that you can keep US law, and New York law in particular, at the sort of forefront of these internationally, you'll help bolster the power of New York finance on the whole as well, and sort of just the commercial status of New York. So they have repeatedly made the argument that there's this synergy between this sort of legal status and this economic status. So I'm sure in that sense, you know, the idea of sort of US power, economic power slipping vis-a-vis China probably does play in here, but I don't know if that just means there's a sort of doubling down on these practices or what. I haven't seen any particular evidence of like US law trying to shift in order to match China or something like that. But yeah, I think it'll be really interesting to watch.
Well, I have a question also, which may not be quite fully formed. But I think I'm curious how you see, or where you see the key distinctions beyond whether they're mundane or exceptional, between the ways that domestic law is regulating sovereign debt, and the way that the US executive branch is using sanctions and designating certain non-state or quasi-state actors as like terrorist groups, which impacts their sort of financial arrangements in all sorts of ways. If you see any sort of connection between these two things, right? Because like I think that you've really highlighted that the extension of domestic law has become mundane and normalized and sort of unquestioned, whereas sanctions are still seen as this exceptional and politicized phenomenon. But I was just wondering if you sort of thought about the relationship between the two.
Yeah, that's a great question. I mean, I don't know if I have thought too directly about that relationship. I think it's really interesting. And one thing that's interesting to me is the way that for many people talking about, you know, I think it's quite common to hear that the executive branch has gotten more powerful in the last few decades, right? And to think about, especially after 9/11 and some of the powers the executive took on and so on. I don't doubt that that's true, but to me what's interesting is that I think this other branch, the judiciary, has also gotten a lot more powerful, and it's been in kind of different domains, but sort of happening at the same time in certain ways. So yeah, but in terms of sanctions or stuff, yeah, I guess I mean, I think one thing that's interesting is the way that sanctions actually interfere with the kind of usual operation of capital markets and trade and so on, right? Often in ways that are actually kind of annoying to a lot of capitalists, right? And so that maybe is one distinction in the sense that, you know, I think that's less true of the kind of judicial extension of power, which has been much more about sort of promoting the general conditions for capital expansion. But yeah, I'm not sure how to answer that actually beyond that, but I do think that's interesting question. Yeah. Do you have any other ideas on it? No. Okay.
No, I was, you know, I was just thinking of whether there's other forms in which US domestic law has impacted other spheres of life beyond sovereign debt. And that was just the sort of one example that I could think of.
Yeah, well, I mean, so this has been much less well developed. For the most part, the US has been much more comfortable expanding, US courts are much more comfortable expanding this kind of law in commercial matters, even as, you know, I think part of that has been redefining what counts as the commercial arena, but they've been much more hesitant to extend this kind of legal power for the purposes of like environmental regulation, for instance, or for prosecuting war crimes or things like that. However, there has been some extension in the domain of terrorism in particular in the last couple of decades, where courts are now getting more involved in. And so you might have heard, I mean, that comes up, for instance, in the question of whether or not some of the victims of 9/11 could sue Saudi Arabia in US courts. That became a really big issue in the last few years. So things like that. So courts have started extending some more power in that way, and then there's much more of a sort of direct overlap in some ways between what's the court's role here and what's the role of the executive in some of these. But yeah, it's a really interesting question.
It really highlights just how powerful the US judicial system could be in climate change, right? Legislation around the world if it chose to unleash its power in the same way, right? Around regulating emissions and things, but obviously it's not done that.
Right. If you could be sued in US courts if your business practices didn't match like the highest environmental standards.
Right. Or if they were to implement some sort of cap and trade system on international commerce and then try them in New York courts, right? That would really be a game changer.
That would be.
It's easier to imagine after hearing your talk, but I don't know if there's any other questions. I don't see any. Maybe we should let Shaina go and enjoy the rest of her Friday afternoon.
Thanks so much for having me. It's fun.
Yeah, Shaina, thank you so much. This has been a really wonderful first talk for our series and just completely fascinating. And as I said, I'm really excited for your book. Good luck finishing it. Thank you. David, I don't know if you would want to say anything else, but. No, just thank you so much. This has been really great. I've learned a lot more about sort of like US domestic law and international finance than I did before. So thank you. Yeah, well, great to be here, and thanks everybody. Yeah, thanks again, Shaina. And thank you everyone for coming. I realize it's Friday and you've got other places to be, so we really appreciate you coming. And thank you all the grad students in the field for showing up. It's great to see you guys here. See you in a few weeks for the next talk. Bye everyone, thank you. Bye, Shaina.